Welcome, everyone. We'll be starting shortly. Next slide, please. Thank you. Welcome again to our Demystifying Public Church webinar. My name is Beatriz Flores Huertas. My pronouns are she, her. I work with the San Francisco Human Services Agency, SFHSA, and I'm part of the communications team.
我個名叫 Brice 啦，我係
Agnes, thank you. A few logistics before we get started. As you can see on the screen, we have instructions on how to connect to Zoom interpretation. This webinar will be interpreted into Spanish and Cantonese, and we'll use the feature that Zoom has for that. So, en sus computadoras moverán su ratón para que aparezca el menú en la parte de abajo de sus pantallas. Ahí encontrarán un globo terráqueo. Oprímanlo y seleccionen español. Agnes?
大家好，歡迎大家嚟參加我哋嘅公共負擔講座。而家咧係給出一啲指引，教大家如何連線 Zoom 收聽我哋嘅粵語口譯頻道。請大家將你嘅鼠標移至電腦屏幕下方所出現嘅選項菜單欄，你會揾到一個地球儀嘅圖標，點擊呢一個圖標就選擇中文頻道，觸碰你嘅智能手機或者平板電腦。tablet 或者 iPad 嘅屏幕咧，直到選項菜單欄出現，再點擊三個點嘅省略符號或者 more 更多嘅選項，然後選擇語言傳譯 language interpretation 之後再選擇中文，再按完成。你應該喺你嘅電腦屏幕上咧就睇得見呢個地球儀嘅圖標。如果你係用智能手機或者平板電腦 tablet 或者 iPad 連線會議嘅話，請點擊三個點。我哋嘅省略符號或者more更多選項，然之後選擇我哋嘅傳譯嘅功能，選擇你所需要嘅語言之後咧，記得最後按完成就 OK 啦。多謝 ，thank you.
Thank you, Agnes. I'll repeat the instructions in Spanish. Para poder escuchar la interpretación en español, en sus computadoras moverán su ratón para que aparezca el menú en la parte de abajo de sus pantallas. Ahí encontrarán un globo terráqueo. Oprímanlo y seleccionen español. En su teléfono inteligente, tableta o iPad, toquen su pantalla para que aparezca el menú de opciones. Opriman más o en los tres puntitos y seleccionen interpretación de idiomas. Luego opriman español y finalizar. Ya deben ver un globito aparecer en su computadora. Si alguien se conectó en smartphone, tableta o iPad, busque interpretación de idiomas en el menú Más o en los tres puntitos. No olviden oprimir finalizar una vez hayan seleccionado su idioma. Let's give attendees a little bit of time to adjust their settings before we continue. To create a space that promotes inclusion and language justice, in today's webinar, we're offering interpretation, which is the verbal delivery of a message from one language into other languages. We're providing the ideal conditions for everyone to communicate fully in their preferred language through interpreters. Language justice also seeks to tear down barriers that exclude less privileged populations, even within the same language, due to the lack of access to opportunities like education, and also due to the digital gap and to organizational cultures that are predominantly Anglocentric. We will use simultaneous interpretation today, in which speakers and interpreters speak almost simultaneously, with the interpreters lagging only a few seconds behind. I'd like to share a few tips that will help us promote language justice today. It's very important that everyone, presenters and participants alike, speak at a moderate pace, just as I'm doing it right now. When it feels like there's not enough time, let's try to be more concise. Less is more. For our questions and answers section rooted in language justice, we're taking the necessary pauses and steps to ensure that information has trickled down to participants listening through interpretation before we open it up to everyone. We understand that attendees have different areas of expertise. We'll try to answer all your questions and we'll follow up with answers afterwards for those we may not be able to answer today. For those of you who are listening to this in Spanish and Cantonese, please type questions and comments in your preferred languages on the Q&A box anytime during the presentation. Another tip for everyone is to make sure to test your audio and use wired headphones. This is extremely important. Following the best language justice practices may all be in vain if your audio is bad and the interpreters can't hear what was said. I think I saw more people joining after we get started, so let's repeat again the instructions about how to connect to Zoom interpretation. We already have this slide here, so I'll go ahead and read again in Spanish, and then my colleague Agnes is going to read it in Cantonese. Para escuchar la interpretación en español en Zoom, en sus computadoras moverán su ratón para que aparezca el menú en la parte de abajo de sus pantallas. Ahí encontrarán un globo terráqueo. Oprímanlo y seleccionen español. En su teléfono inteligente, tableta o iPad, toquen su pantalla para que aparezca el menú de opciones. Opriman más o en los tres puntitos y seleccionen interpretación de idiomas. Luego opriman español y finalizar. Ya deben ver un globito aparecer en su computadora. Si alguien se conectó en smartphone, tableta o iPad, busque interpretación de idiomas en el menú más o en los tres puntitos. No olviden oprimir finalizar una vez hayan seleccionado su idioma. Agnes.
大家好啊！而家咧係給出一啲指引，教大家如何連線 Zoom 收聽我哋嘅粵語口譯頻道。請大家將你哋嘅鼠標移至電腦屏幕下方所出現嘅選項菜單欄，你會揾到一個地球儀圖標，點擊呢個圖標，然之後選擇中文頻道。你亦都可以觸碰你自己嘅智能手機、平板電腦 tablet 或者 iPad 嘅屏幕，直到選項菜單欄出現，再點擊3點呢個省略符號或者more更多呢個選項，然後咧選擇語言傳譯 language interpretation 之後咧，再按中文同埋完成即可。你應該可以喺你嘅電腦屏幕上面咧就睇到呢個地球儀嘅圖標。如果你係用智能手機、平板電腦 tablet 或者 iPad 連線會議嘅話，請記得點擊3個點省略符號或者more更多呢個選項，然之後選擇傳譯呢個功能。選擇你所需要嘅語言之後咧，記得要按呢個完成按鈕，咁就 OK 啦。 Thank you.
Thank you, Agnes. And as a reminder, please enter your questions in Spanish, Chinese, or English using the Q&A box at the bottom of the screen. We'll read out loud and answer questions at the end of the webinar. To submit a question, you can tap Ask a Question at the bottom of the screen, enter your question into the Q&A box, and then tap the Send button to send your question to us. Our facilitators today are Ariel Brown and Erin Quinn from the Immigrant Legal Resource Center, ILRC. Please remember to enter your questions in English, Spanish, or Chinese in the Q&A box. Before I hand it out to Ariel, let's hear from one of our leaders at SFHSA, Susie Smith. Susie is the Deputy Director of Policy Planning and Public Affairs at the San Francisco Human Services Agency. Susie, the floor is yours.
We have partnered with the Office of Civic Engagement and Immigrant Affairs, or OCIA, and the Immigrant Legal Resource Center, or ILRC, to create this webinar to address public charge and related immigration concerns that often prevent immigrants in San Francisco from applying for needed benefits such as Medi-Cal, CalFresh, CalWorks, and just a quick summary of our agency. You may already be well familiar, but in case you're not, SFHSA, your Human Services Agency, provides the foundation for two separate city departments. We're part of the City and County of San Francisco. We are big and we serve a lot of San Franciscans. We support about 1 in 4 community members, or almost 200,000 San Franciscans, with a wide range of help, from food assistance to cash assistance to medical insurance to Medi-Cal. And we help people from all stages of life, from when they're born, children, families, seniors, and people with disabilities. This includes supporting undocumented residents of our city. We know, though, that understanding and accessing our benefit programs and other services can be confusing and bureaucratic. And we know that sometimes this results in people just giving up and not wanting to actually go through the process of getting the support that they not only need, but are legally entitled to. Through our ongoing work with organizations like yours and community members, collectively, we have identified that public charge is controversial and confusing, and it has been an issue that we have struggled to try to communicate more clearly for many, many years. This is why we have created the space for an open dialogue where you can ask questions and that you have yourself or that you have heard from clients. We really want this to be the opportunity to ask as many questions as possible. So we've reserved a lot of time for Q&A. We hope that at the end of our time together, you can help clients understand this topic better and encourage them to apply for benefits and services and maintain those services. Today, we have both immigration experts and public benefits experts to help answer your questions. Thank you for your partnership. I hope that this is informative and that you learn a lot, and I will now hand it back to Beatrice.
Thank you, Susie. We also have Richard Whipple with us today from OCIA. Rich is OCIA's Deputy Director. Rich, go ahead.
Thanks, Beatrice, and good morning, everyone. Thank you for being here. My name is Rich Whipple. I use he, him, his pronouns. And as mentioned, I'm the Deputy Director of the Office of Civic Engagement and Immigrant Affairs. We are a city and county agency similar to the Human Services Agency, and our mission is really to promote inclusive policies that foster immigrant assistance programs that lead to full civic, economic, and linguistic inclusion. Just to add to a little bit to what Susie shared, we're mindful that the previous federal administration's attacks on immigrant communities and attempted changes to many policies, including public charge, has really left a lot of confusion and fear in our communities. And even despite the Biden administration's return to previous longtime definitions of public charge, we know that many immigrants remain fearful and avoid benefits that they are entitled to and that they need. So we know these benefits in many cases will have no impact at all on their immigration, but folks still remain fearful and concerned. So I just wanted to kind of frame up front that public charge rules in the first place, as you'll hear from our experts in a moment, really only apply in limited circumstances in the first place and for limited individuals. So I think having this space to be clear about who is impacted by public charge and when is really essential and really important. And I just wanted to thank the Human Services Agency's fantastic team for putting this together, for really dedicating time to this issue and immigrant-specific outreach projects, and for being intentional around language justice and creating a space that is multilingual and inclusive. I also wanted to thank our amazing team here at OSEA, the Office of Civic Engagement and Immigrant Affairs, especially the team that's providing interpretation services today and that coordinated interpretation services today so that more folks can participate in their preferred language. And wanted to also share that you can learn more about our office on our website, which is sf.gov/OSEA, OCEIA. And lastly, I wanted to just say a big thank you to the Immigrant Legal Resource Center that we are super fortunate to have based locally here in San Francisco, but that does such phenomenal work around the country, really building capacity of service providers, immigration legal providers, and cities and counties like ours. So thank you everyone for being here, and hope that you enjoy and learn the things that you need to make sure that our immigrant community is confident in getting the benefits that they need to thrive. Thank you.
Thank you, Rich. I now introduce you to Erin Quinn. She's Senior Managing Attorney with ILRC. Go ahead, Erin.
All right. Thank you, Beatrice. Thank you, everyone. It's so great to all be assembled here together in community to talk about this issue. And we really appreciate everyone who was part of making this happen. As Rich says, HSA, OSEA, and all of you here to present and share knowledge and to interpret for us to make the space open to all. My name is Erin Quinn. I'm a senior managing attorney at the Immigrant Legal Resource Center. My pronouns are she, her, and I'm joined today by Ariel Brown, who is an expert in public charge and also a senior attorney here at the Immigrant Legal Resource Center. And we will be discussing various ways to think about and talk about public charge, while at the same time, hopefully, making all of this a little more clear along the way. We hope, though, beyond just making this issue clearer, that you walk away with your own ways to talk about public charge. So our presentation today, you'll notice, has really nice sound bites for you that you can share after today in your communities. Just a quick word about the Immigrant Legal Resource Center, if you're not already familiar with us. We do a variety of different activities around immigration law and to support immigrants in our communities. So some of the work we do is training like this one to build the capacity of service providers and legal service providers around immigration legal issues so they can support those that they serve. But we also do a lot of work advocating for fair and just policy, improving the policies facing immigrants nationwide and at the local level throughout the United States. And we also work directly in immigrant communities, helping to raise voice and educate around important issues like this one, public charge. So that might mean community meetings in various places in California and in other regions in the United States. We have offices now in Texas, in California, and in Washington, D.C. to help us meet these goals. But with that, let's talk about why we are here today. So we're here to talk about public charge, demystify what that term means. And we're going to start by talking just briefly about immigration in general to set the stage. But before we do that, let's go ahead and look at a poll for all of you to weigh in. So our first question before we dig in is, right now, how do you feel about public charge? You can weigh in whether you feel confused, confident, in the middle. maybe we should have let this just be smiley faces, emoji responses, so you could all weigh in how you feel on Wednesday. Okay, I think the results are getting shared right now. Is that right? Okay, let's share results. So we have a lot of people in the middle, a handful of people confused, and a couple of us, maybe it was Ariel, who says they feel pretty confident right now. So I think we're all in the right place together. I will note that we have all different types of providers on this webinar here together. And that means I know that I've seen some legal immigration service providers, some community workers, some benefits providers. And today we've left lots of time to hopefully address all of your questions, but we will be setting the stage for all of those on this call. If you have advanced legal questions, we do hope to help you too. But in addition, as legal providers, what we hope you walk away with are strong messages to share with your clients and those that you work with. So first, before we even jump in, we want to set the stage around what we're talking about, which is generally one piece of immigration law. And in order to understand some of what we'll discuss around public charge, it's important to recognize that there are all different types of immigrant status, that not all immigrants are the same. There is so much out there beyond US citizen and permanent resident. We have those that are unfortunately without status, but we also have people in a variety of in-between statuses, from what we call temporary protected status to certain visa holders to DACA, which many of you are familiar with, deferred action for childhood arrivals, and green card holders or permanent residents. So we have so many statuses, not even all of them are here on your screen right now. And so those that are asking you questions about public charge might be in a variety of different situations. What we also know about our important and strong community here in California is that many families have what we say mixed immigration status. It is very common that you will have individuals in a household that present with a variety of different immigration statuses, from US citizens to those that are undocumented, and how they feel about public charge for their family is impacted by the confusion of different statuses in the household. So we hope that we can address those concerns as we talk to you today. Importantly, and unfortunately, not all statuses are treated equal under our immigration laws. And so we often are talking about what many say is a pathway to US citizenship, that folks might enter this pathway at different points, either starting with no status at all, or entering with a visa, or entering as a green card holder, or entering the United States as a refugee. But any of those paths require that the person become a permanent resident before they become a US citizen, and that is the pathway to US citizenship. Some types of immigration protection or status do not lead to citizenship at all. So while they help people remain here without fear of getting deported, like DACA or TPS, those individuals, unless they have a change in what their status is, are not immediately on a pathway to become a US citizen. You'll hear us refer to these different categories during today's presentation. You'll see people mark things like LPR or TPS, Immigration is truly the alphabet soup of acronyms. So a couple important ones is LPR, or permanent resident, lawful permanent resident, is the same as a green card holder. And that will be important for a lot of you in terms of considering outreach around benefit access and around how public charge fits in. So let's go ahead and just jump in with what is public charge. And to do that, we're going to ask you a couple more questions. So let me share another poll for you. Now we would love to know, how often are you in your role asked about public charge? Perhaps every once in a while, not that much. For some of you, maybe every day.
If I may add, Erin, for attendees today, you will see the pop-up screen that has that question that Erin just asked. And if you're joining from your computer or a smaller device, and you don't see the complete question since it includes English, Chinese, and Spanish, just toggle over the question so that you can see the full information in the 3 languages and choose your answer. Thank you, Erin.
All right, a lot of you were able to weigh in, and most of you are getting asked questions about public charge, either every once in a while and some every day, with about 25% saying not that much. And we have a little editorial that since Trump left office. And the reason why that is important, as Rich has already highlighted, is that we are back to longstanding policies around public charge that predate or that were in place before the Trump administration. So for many, there is no more public charge concern for them in their immigration pathway. But the problem is that the fear lives on, and our job now is to give clear messages so that everyone knows that public charge is likely not a problem for them. And we'll set that up and discuss that more deeply over the next handful of minutes with you. So what is public charge? The most important thing that we want you to take away today is that we want to put public charge in its place. Public charge is actually just one teeny piece of immigration laws about who can enter the United States legally or get status here after they have entered. It is one of many different tests or criteria that are applied when somebody applies for status. And I think that this term, public charge, has become bigger than what it really is in immigration law. The term public charge has very limited impact for those that are seeking legal immigration status. But we hear about it all the time in the media as some big negative thing that might apply to anyone who tries to access benefits or services. What we hope you walk away with today is a clear understanding that public charge only applies to a small set of immigrants, and even then has very limited impact on what benefits a person can access. So just generally speaking, what is public charge? We hear this term thrown around a lot. Like I said, it's just one small sentence of our immigration law. And really what it becomes is a small test or assessment about whether someone is likely to become primarily dependent on benefits in the future. And it is only applied when a person applies for certain benefits. So it's not just hanging out there as something that applies to everyone in the United States, nor is it a rule that applies to all immigrants. A person has to be applying for certain benefits for this test to even come up or be applied to them. So more specifically, there is a definition of public charge that everyone, if it is applied, any officer must use a very specific and narrow test. We'll talk more about this later on, but generally speaking, it is a law that says that in specific situations, specific applications, an immigration officer will be considering whether someone is likely to become primarily dependent on a cash aid program or long-term institutionalized care. And so this is actually a real small subset of the benefits and programs that we have available to us. We'll learn that this law does not affect all immigrants. It only affects a small group, and that this law has nothing to do with who is eligible for our benefits and programs. Particularly here in California, we have robust programs and benefits available to our entire community and citizenship. And these programs, if the program says they're eligible, a person can use that program regardless of their immigration status. Some programs require specific immigration statuses, but public charge is a separate law, and it's only applied when you're seeking an immigration benefit. So let's break this down. The first thing we want to break down is that access to benefits is not impacted by the public charge law. So public charge has nothing to do, as I just mentioned, with who is eligible. In California, we have many programs that do include immigrants and their families. A really strong example of this is our general protections for healthcare under full scope Medi-Cal. In California, Medi-Cal is available to anyone through the age of 25 and anyone age 50 and over, regardless of immigration status. Anyone that qualifies for Medi-Cal can use Medi-Cal without worry about public charge. And there are a few reasons for this. First, because Medi-Cal is a health program, and we'll learn that health is not part of the public charge test at all. And so that's a main reason. And second, using that program for a benefit or a benefit and health benefit that you qualify for has nothing to do with public charge. So if the person is not applying for an immigration application, it doesn't matter that they're using a program that they qualify for in California. So if we think about that and think about maybe how public charge is coming up for those of you that are getting asked questions around public charge, let me just ask you one more question as we start this off today. So our question for you is, in what capacity are you asked about public charge? Is it that you work for an HSA or another agency where you're getting asked about benefits? Is it that you're in immigration legal services and you're getting asked about public charge? Or do you work in some other capacity helping your community? And for this reason, you're on today's call. All right, let's see how people are doing. So many of you are working in some organization where you're getting asked about benefits. A lot of you work in some other capacity and are just curious about public charge. So I imagine A lot of you are doing outreach and helping in your communities and are hearing a lot about the fear around this law. And then a handful of you do direct immigration legal services. And so it comes up in that context. So we wanted to ask this question here because the access to benefits, one big takeaway, is not impacted at all. You can give the information you have around eligibility for a benefit, and that will remain true no matter what happens around the public charge law. Public charge, just a spoiler alert, now only looks at cash aid and long-term institutionalized care. So Ariel will look at this in detail, but a big spoiler alert that all our programs around health, housing, and food are safe to use for all immigrants. If you remember at the beginning, we sort of highlighted that there are so many different types of immigration status. So before we even dig into more details about the public charge law, just know that many immigrants don't even have a public charge test. The status has no public charge test applied. All refugees and asylees do not have that public charge test. Anyone qualifying for certain special visa statuses, like the U visa or T visa, are exempt from public charge. There is no public charge test for those that are already green card holders or permanent residents, and US citizens are exempt. So remember, when I spoke about families with various immigration statuses in the household, it might be that many of those family members can use any benefit at all that they qualify for without worry about public charge. The other important piece is, if you remember, I mentioned that public charge only comes up if you're applying for a certain immigration benefit that has a public charge test. So only some immigration applications apply a public charge test at all. The most common one, and the reason we still talk about public charge, is that those applying to become a green card holder or permanent resident through a family member visa, that is a space where a public charge test does apply. All of those other statuses, we'll look at it again, have no public charge test. So an example of when we do worry about public charge is something like Yali on your screen. Imagine that Yali marries a US citizen and Yali's spouse files a petition for her in the immigration side. Based on this relationship and that petition, Yali can apply to become a permanent resident of the United States. In that type of process, Yali will have a public charge test applied to her. But what we will learn is that most benefits, even for Yali, are safe to use. So the big takeaway is that we really need to make public charge seem smaller and put it in its place. So public charge as an immigration law will only apply if somebody is trying to enter the United States and are getting screened at our border for reasons that they might not be allowed to enter, or when they are applying for a green card, most commonly through a family member. Those are the only two circumstances where a public charge test applies. So if someone is applying for a different kind of immigration status, no public charge test. And if someone is just here in the United States and is currently not applying for anything with immigration, let's say they have no status, but they're not applying for anything, there would be no public charge test because public charge is only applied if the person comes forward and applies for one of these two things. That means that they could be applying for all different other types of statuses and not be worried about public charge. They could be applying for a DACA status. They could be applying for a U visa or asylum. They could be even eligible for a green card through a different pathway, not through marriage or a family member, and have no public charge test. And importantly, permanent residents applying to become citizens, the naturalization process, has no public charge test. So what do you think? Given all of that information, if somebody who has a green card is applying to renew their green card, what do you think? Are they subject to public charge? You can think this in your head. You can try to shout it out, yes or no. Simple answer here, no, no public charge test. A person who already has a green card and just needs to renew that card will not face public charge. What about applying for citizenship? We get this question a lot. Someone says, oh, I can't use Medi-Cal, or I'm worried about housing because I want to become a citizen. I'm a green card holder now. But the answer is they can still use those benefits because there is no public charge test to naturalize. So some of the law people on this call are like thinking now, does a green card holder, somebody who's already a permanent resident, ever need to worry about public charge? So the quick answer is pretty much most of the time, no. Most green card holders here in the United States, and particularly in California, will be eligible for many, many programs and benefits, and they will not be facing a public charge test. There is only a very small way a person might be able to trigger a public charge problem as a green card holder. And that would be if somebody was outside the United States for more than 6 months. It might be if they were already facing deportation for another reason and needed to get a new green card, they had to apply. But these are complex legal situations. A regular permanent resident in the United States can use any of those benefits that they qualify for. So thinking of Maya, this is maybe one of the typical questions. Let's say she has a green card and she is ready to naturalize to become a US citizen. But she says she's worried about public charge and whether it applies to her. Sometimes a person like Maya comes into our organizations and says, well, unfortunately, I use food stamps. I can't become a citizen. But the answer we can give Maya is that's not true. You do not need to worry about public charge. There is no public charge test to go through the citizenship process. And in fact, Maya, if she does use benefits, probably qualifies for a fee waiver so that the naturalization process is cheaper or potentially free. So we need to tell Maya, exercise your right to become a citizen if this is your only worry. Here are some other examples, thinking about all of those possible different immigration situations. Think about Jesus. Let's say Jesus has DACA and he has no immediate way legally to apply for a green card. He has deferred action for childhood arrivals, DACA, but he has no eligibility or way to turn in an application for permanent residence. So in that situation, Jesus does not need to worry about public charge or what types of benefits that Jesus uses, because there is no public charge test to get DACA or to keep DACA or to renew his DACA. And because Jesus isn't right away applying for a green card through a family member, there is no public charge test that Jesus will be worried about. How about Chris? Let's say Chris is engaged to a US citizen who wants to petition Chris for immigration status. Chris will need to consider public charge as part of their application for a green card. So Chris, even if they are eligible for cash aid, might choose not to use that program. That is that limited situation where we worry about public charge. The big takeaways is that when we talk about public charge, it's not as big as all the negative rhetoric and things that we see in the media, that we need to communicate that it only applies when filing for certain immigration benefits, that only some types of immigration categories or statuses even have a public charge test. And the big one that I want to say out loud is that public charge is not an immigration enforcement tool. I think in reality, many of the questions we get around public charge are because families that are eligible for benefits in California are worried that if they apply for that benefit, that somehow immigration enforcement will come to their house for those that do not have status. And so we need to find ways to communicate that public charge is not an immigration enforcement tool. It is only a test about eligibility for getting a green card or for entry into the United States, and that you can turn in an application for a benefit in California and not worry about immigration enforcement. And so with that, I want to turn it over to Ariel to take us a little deeper into public charge.
Thanks, Erin. So now that Erin has given us the background and overview on public charge, I'm going to provide an update on the status of public charge today. So if we could go to the next slide. So Erin talked about what the immigration law says on public charge, and only Congress can change the laws. But in addition to the law, we also have extra guidance and details on public charge, which come from federal regulations, which we often refer to as rules. During the Trump administration, they came out with a public charge rule that is no longer in effect. The Biden administration came out with its own public charge rule in late 2022, and this rule is in effect now, since December 23rd, 2022. The new rule does not change any of the foundational principles on public charge, which come from the law that Erin discussed. It's simply meant to stabilize and strengthen public charge policy as a safeguard against another administration trying to make changes the way that the previous presidential administration did. If we go to the next slide. So for more than 20 years before President Trump was in office, as Erin said, we did not have an official final public charge rule, but we had long-standing informal guidance dating from 1999. Under this long-standing guidance, public charge was not a huge issue. That's why most people hadn't heard of it or barely thought about it before Trump took office. This is what Erin was talking about earlier in terms of putting public charge back in its place. As she was saying, it really is just a very small part of immigration law. It grew into this really big and scary thing during the Trump administration, and now we want to put it back into its much more limited place. So during the Trump administration, if we could go back to the other slide for another moment, we saw this harsh rhetoric on public charge, and it made many people afraid to use even public benefits programs that they or their families qualified for simply because they were immigrants. Or maybe, as Erin mentioned, they lived in what we call a mixed status household. So immigrants and people who maybe are US citizens or other immigration statuses, all living together under the same roof. And so the Trump administration extremely harsh public charge rule luckily was only in effect for a brief period of time and actually resulted in very few immigration cases being denied on this basis. But as we keep talking about, the damage has been much more long lasting, both before and after this Trump rule was actually in effect. We continue to hear about people who are afraid of public charge and the immigration consequences. And now we're in this post-Trump space where we have a new rule that, as I mentioned, took effect at the end of the year, does not drastically change things from long-standing policy, but rather solidifies and strengthens this long-standing guidance. Now we can go to the next slide. So as Erin explained earlier, public charge says that in certain situations with certain immigration applications, an immigration officer can determine that someone is likely to be primarily dependent on the government for support. And the new rule provides us with some more specificity for this definition. It says that primary dependence on the government for support is shown by reliance on just two types of programs: cash assistance for income maintenance, and this includes SSI, temporary assistance for needy families, or TANF, CalWorks, also CAD in California, or long-term institutionalized care paid for by the government. In California, we mean if it's paid for by Medi-Cal. No other benefits programs count or can be considered as part of evaluating whether someone is likely to be a public charge. So if we go on to the next slide, this means that many, many other programs do not count, including, but not limited to, all of the programs that are listed on this slide. So to highlight a few, and these are ones that briefly counted during the Trump era rule, but do not count now. And so that would be Medicaid or Medi-Cal, apart from if Medicaid or Medi-Cal is used to pay for long-term institutionalized care. We're talking about someone who has to live in a nursing home and the government is paying for that. Section 8 and other public housing. Food stamps do not count, also called SNAP or CalFresh. WIC does not count. COVID vaccines and treatments do not count. Free and reduced cost school meals do not count. Head Start does not count. Any earned benefits, so you're paying into it when you're working and it's being taken out of your paycheck as part of your taxes, right? So unemployment benefits, Social Security retirement, workers' compensation, also veterans benefits. Also, right, we're in the midst of tax season. Tax credits do not count. And, really any other federal, state, or local benefits that are not cash aid for income maintenance or long-term institutionalization. So if we go on to the next slide, the new rule also makes it very clear that family member use of public benefits does not count. Even if the applicant who is subject to a public charge test, like if they're a parent of a US citizen, they might help with the benefits application paperwork. They might even be named on the notices because they're the parent or guardian. But if they do not qualify and are not actually the person receiving the benefits, their family member use will not be considered in their own public charge test if they are subject to a public charge test. So let's look at this with an example. Laura is undocumented and her children are US citizens. Her children qualify for benefits. But Laura worries because of her status that her children shouldn't sign up. So what could you tell Laura? I think if we hit advance, we can get the answer on the slide. So Laura's children's use of benefits will not impact her in a public charge test. And then also Laura isn't even subject to a public charge test right now. As Aaron talked about earlier, it's only for certain applications. Right now, we just know that Laura is undocumented and we don't know about what type of immigration application, if any, she might submit in the future. You know, she applies for asylum or a U visa, even then she wouldn't be subject to public charge. So bottom line is, even if she were subject to public charge, some hypothetical application in the future, her children's use wouldn't count. So absolutely, her children should access the benefits they qualify for and need. And then we have another example. Okay, so Daniel is a US citizen and he receives financial aid. His parents are undocumented. But Daniel's worried that his use of financial aid will affect his parents in a public charge determination. So first question, and we're going to put this out to all of you as a poll. Does Daniel, who's a US citizen, need to worry about financial aid and public charge? So you should see the poll on the screen now. This is great. I am seeing overwhelmingly that most people are saying no, he doesn't need to worry about that. So that's right. He's a US citizen. US citizens don't have to worry about public charge. And we talked about family member use of benefits doesn't affect the other person. So his parents aren't receiving the financial aid. And so it shouldn't affect him. It shouldn't affect the parents either. So then let's look at sort of a slightly different question. What if Daniel were also undocumented? So here I'm seeing a little bit more split between yes and no. More people are still saying no, but we have sort of a split between the two. So the answer again is no. If Daniel were also undocumented, you know, maybe he in the future could be subject to a public charge test, you know, like Laura before. If someone is undocumented but isn't submitting an immigration application, there's no way for us to say whether or not they're subject to a public charge test because it would depend on their immigration status or application that they're submitting. But even if you were subject to a public charge test in the future, the new rule says that student loans and publicly funded scholarships and educational grants do not count. You know, and if there was a question about the type of financial aid he was receiving, we would definitely say that the financial aid program is supplemental, it's special use, it's just for education, things like books. It's not general support and income maintenance, which is the only type of aid, cash aid for income maintenance that could potentially count. And then just to move on to the next slide is even if someone is receiving a public benefits program that might be considered, so cash aid for income maintenance or long-term institutionalized care paid for by the government, it's still just one piece of the public charge analysis. So, although the receipt of benefits is what most people focus on when they think about public charge, when immigration officers are evaluating public charge, they are required to look at a person's full life circumstances. So receipt of benefits that count is part of that, but it's just one piece. They're also supposed to look at a person's age, health, work history, etc. And because the public charge test is supposed to make a prediction about the future, whether someone is likely to become a public charge later on, even if in the past for a brief period of time they received some type of public benefits that count, that doesn't necessarily mean that they are going to be reliant on those in the future. And then lastly, we want to emphasize there's this other application form called the I-864 Affidavit of Financial Support. And it's something that someone's sponsor must submit for them when a green card holder or US citizen family member is sponsoring their relative's green card application. This affidavit of support is strong evidence that someone is not likely to be a public charge because the sponsor is promising to support them if they need it. And then another part of that we'll touch on is, as many of you know, there's this thing called sponsor deeming, which has the practical effect of disqualifying people who have been recently granted green cards from benefits eligibility because the sponsor's income is included. So speaking of sponsors, many people worry that they will hurt their sponsor if they use public benefits. And that's the main reason that they don't use them, even if they qualify for them. So we can give clear answers to these concerns about sponsors. Sponsors are not subject to a public charge test themselves. And as I mentioned, sponsor deeming just means that when a benefits granting agency is determining whether someone meets income eligibility requirements to receive certain benefits, they will factor in the sponsor's income. The sponsor will be unaffected by this, but it might mean that the non-citizen who's applying for benefits won't qualify based on income. Also, people often worry about the sponsor having to pay back public benefits that someone they sponsored received. But in California, we have no way to ask a sponsor to pay back benefits received by the person that they sponsored. So if we go on to the next slide. So in sort of the last section of our presentation, before we go into Q&A, we wanted to talk about what people can do if they're worried or still have questions about public charge. So if we go to the next slide, first thing is just to summarize these key points. Public charge does not change eligibility for public benefits. I know we've been saying this over and over. It also doesn't apply to all public benefits programs or all immigrants. And then the Immigration Service, if they are doing a public charge assessment for someone who is subject to public charge, they will not consider family member use of benefits. And then finally, public charge does not apply to all immigrants or all immigrant applications. It only applies in two main situations that Erin outlined at the beginning. When a person is applying to enter the United States or applying for a green card sponsored by a family member or employer. And with that, I'm going to turn it back to Erin to close out with some more suggestions and resources, and then we'll get into the Q&A.
So I think there's still just this, how do we come at the fear or the confusion that we see when we're trying to help answer all of these questions? And I think another way to come at this is to encourage those that have concerns to get a consultation. So there's a sort of step one, stay informed. While a lot has been changing in the immigration space and around public charge, there are so many resources available. We do keep our website up to date on public charge. Right now, we believe that public charge policy will be quite stable for the time to come, because we are back on really long-standing principles. But it's great to encourage people to get consultations. We often talk to people about this being kind of like a doctor's checkup. You might have gotten immigration advice 5 years ago. Some people say a decade ago. And one way to feel empowered and feel more in control is to get an immigration checkup. Go in and make sure that you understand and learn your options. Because there's been so much changing in the immigration space, it might also be that the person now qualifies for a benefit that they did not know about on the immigration side. So that is one way that you can refer people. And for all of us, another way for us to impact what is happening for those in our community is to just get involved and raise your voice to support better protections and policies for immigrants and our communities. There are a lot of opportunities for this here in our communities in California and the Bay Area specifically. In public charge, a lot of where we are now, which is a very safe place on public charge, came after everyone raised their voice around the bad policies coming out of the administration before. And over 200,000 comments were received by the federal government in response to the bad public charge policies. So if we stay active and raise our voice, we can have an impact. If we are telling people to get a legal checkup or go for a consultation about their immigration case, it's important that folks go to a trustworthy individual. We can remind people that only attorneys and accredited representatives by the Board of Immigration can give legal advice. So if you feel like you're getting questions that are beyond benefit eligibility or some of the general messages that we shared today, you can suggest they go to a legal service provider to answer those questions. We can also educate people that a good legal service provider will provide a contract, that they should provide receipts if you make payments, and they should be comfortable explaining the process and answering questions. So if a person isn't willing to answer very important questions and concerns, then that might not be the right legal provider for you. There are incredibly great resources for us, particularly around organizations that can handle public charge questions. The ILRC has a list that directs to a national directory of nonprofits that provide immigration help. The California Department of Social Services also provides a list of those that can provide immigration help here in California, and particularly on public charge. And as Rich has described earlier today, OSEA has a portal for immigrants in San Francisco that can be very helpful and direct to specific services. And that is now in the chat box at immigrants.sfgov.org. So there are a lot of really great places to direct people on the web so that they do not go just for advertisements of those that might not be the best providers for their questions. And just a reminder that the reason why this might be important is that a person really should be screened to identify if they have possible options on the immigration side. Obtaining an immigration status is one amazing way to stabilize families that are feeling at risk, either economically or in other ways. And so directing folks to services to screen for immigration options can be a very important service that we provide. For instance, some of us might be in a role where we learn about domestic violence or that a person has been a victim of a crime. And in those cases, we really want to encourage that person to get a legal checkup because those problems might qualify them for immigration status. In addition, we want to make sure that those that are fleeing fear in their home countries are screened for asylum and potential protections. And then in addition, an immigration legal service provider might be able to assess special situations to help a person get a green card, like parole in place or special protections for military family, or identify that someone might be a citizen and doesn't even know it. So for all these reasons, it's really great to have as one of our roles encouraging people to double check their immigration options. If you do want more information about public charge specifically, or you're worried that you see in the news or hear on the radio some update around public charge, we encourage you to check trusted resources for those updates to make sure that we understand if anything has really changed. Sometimes in the media, things are reported as dramatic or dire, when in reality, the protections that are offered might not have actually changed. For public charge, we keep our website up to date with any policy developments. You can also check out the national campaign around protecting immigrant families, both for good resources for communities and also for ways to get involved at your organization or in your role to raise your voice around these important issues. We also have a partner organization, NILC, that also is really one of the leads around public charge issues and issues around work permits and economic support. They have a lot of great resources as well. And so with that, I will turn us to our questions page. I know we really want to spend a bulk of today making sure we answer your specific questions. And quickly just note that Rich has also shared important links for our local OSEA options and around public charge.
Thank you, Erin and Ariel. That was a great presentation. So we're going to get started with the Q&A section right now. Again, besides Erin and Ariel from ILRC, who are going to be able to answer any questions you have about public charge, we also have HSA's program experts who will be helping us answer any questions related to public benefits. Thank you for submitting your questions through the Q&A. Again, if you have any other questions, feel free to type them in your preferred language, English, Spanish, or Chinese. So I'm going to go ahead and get started with the questions that we've received. So the first question I see is, will we be provided with contact information for the presenters? So Erin and Ariel.
We can provide that, but probably a better tool for most people on this call is to know about our Attorney of the Day service. And I don't know if I'm able to share an email in chat. I'm noticing it's going to host and panelists. But the email that is best for answering questions about public charge is AOD ilrc.org. That stands for Attorney of the Day at ilrc.org. And this is a space available for all nonprofits in the Bay Area and service providers to ask your legal or immigration questions. Most of you on this call qualify to use that service to ask specific questions. So if you do have lingering questions about a case or public charge, if you direct them there, one of the staff attorneys at ILRC will be able to respond.
Thank you, Erin. The next question is, what is LPR?
So LPR stands for Lawful Permanent Resident. And so LPR is shorthand for those that hold a green card or have gotten permanent residence in the United States.
Thank you. The next question is, will this recording be emailed out to people who attended after the webinar ends? And that's correct. Just give us a few days to get all the materials together so we can share them. And we also have the slides translated into Spanish and Chinese. Those were emailed to folks who register requesting either language today. So we'll go ahead and share all of the languages of the slides and the recording as well. The next question is, does that mean that a person who is not a legal permanent resident can get full medical then instead of just emergency medical? So I think this question, I'm gonna ask this if Carla can answer this.
Sure, good morning. So earlier, well, maybe I was daydreaming, but yeah, so regardless of the immigration status, if you are under the age of 26 and also older, between 50 and older, then you can go ahead and receive a full scope benefit.
And that's regardless of immigration status.
That is regardless of your immigration status, that is correct. So so let's put it this way, children under the age of 19, and then those, young adults, 19 through 26. And then we have the 50 and older.
Great, thank you. The next question I see is, if a family says they do not qualify for medical, would it be due to income? We have families who say their children have medical, but not themselves, in parentheses, the parent. Erin or Ariel?
Yeah, that sounds related to me to the answer, thank you, Carla, that she just gave, that it's really about medical eligibility. And so it might be that if the children qualify and the parents do not, that perhaps the parents are between the age 26 to 49. But even so, they would qualify for emergency services. And so if there are concerns beyond that, it might be good to direct them to who can help around benefits eligibility.
Carla, do you have any contact information maybe for folks who have questions about income eligibility or specific situations in their family when they're trying to apply for medical?
May I also add something? Usually when you get discontinued or denied from medical, and when I say denied, that's for new applicants. Discontinued, that means that you were already receiving benefits. There should always, the county also, like besides discontinuing or denying your benefits, they will let you know the reason why you're being denied. So there are many reasons why you get denied or discontinue. It could be because you are over the income limits, right? And if you have a parent or kids, the kids have higher income limits, and that's why the parents sometimes go to Cover California. Also, if you're pregnant, the income limits are higher. It can also be because the family or the individual, they fail to provide mandatory verification. So they could be, one of the reasons why they were denied or discontinued from benefits. Like I mentioned earlier, the notice of action always has the specific reason why you were discontinued. And it also has a phone number for a fair hearing if they need to file a fair hearing. I can find the 1-800 number, and I can also provide it to you so they can call our agency if they have any questions regarding the reason why they got discontinued.
Thank you. I understand there's also an email address that we have for Medical, and so we can share that in the chat. And if not, if we don't have it available, we'll share it afterwards when we send the materials. The following question is, what do people have to do to prove that they are not public charge? Are there any documents that they need to turn in to prove this? Erin or Ariel?
Sure, I can take this one. So there aren't any extra documents on top of what they submit with the application, but on the general applications, there will be questions that do relate to this inquiry. So if someone is subject to a public charge test, the immigration officer is going to look at things like their health, their household size, the possible current or past receipt of public benefits that count, their work history, etc. And this information would just be part of the general application.
Thank you. Next question. There are many reasons why an individual, sorry about that. Let's say, actually, it's if a family member petitions for another person to become a legal permanent resident, then I assume they will have to worry about public charges, correct?
So that's correct in a way, right? Which is that if somebody is applying to become a permanent resident through a family member, then that applicant, the person who is applying for the green card, worries about public charge. The family member that is a U.S. citizen or permanent resident, the sponsor does not have their own public charge test, but will be helping by filling out that I-864 that Ariel had described before. So only the applicant faces public charge. The sponsor might be using benefits, and that does not necessarily mean a problem for the application.
Thank you. Another question, does that mean that a person who is not a legal permanent resident can get full medical then instead of just emergency medical? I think we already addressed that question. All right, so the next one is, can you use public benefits temporarily if you are DACA and later you try to become a legal permanent resident or I'm guessing United States citizen? It says USC.
Yeah, USC is like the LPRs are shorthand for US citizen. I guess I can answer from an immigration perspective, and then I don't know if we wanted someone from the public benefit side, but from the immigration side, yes. If you later try to become an LPR through a family member or employer petition, then you will be subject to a public charge test, but past use of benefits might not matter, maybe because they weren't benefits that count. Remember, there's only certain types of benefits programs that count, or maybe it was a long time ago or for a short amount of time. And when the immigration officer is looking at the applicant's full life circumstances, they still decide that that person doesn't seem likely to be reliant on the government for support in the future. So they should absolutely use them now, and it's hard to sort of predict down the road if they are subject to public charge test, you know, the impact that it will have.
Thank you. Next question, how do the new laws apply to CAPI being a state benefit? Do we have any program experts who are familiar with CAPI or I don't know if from the legal side of things, if Ariel and Erin can speak about that?
So if no one from benefits wants to address it, my understanding of CAPI is that this is one of those potential cash benefits, so that if someone is facing a public charge test, so remember, we've already put public charge in its place. So if there is a public charge test, CAPI use can be considered in that decision.
Great. Do any of our HSA folks know about CAPI and have anything to add? Sounds like we don't have anybody who has more information, but we'll look into that and share that afterwards. Next question is, how does the public charge rule apply Medicaid deeming programs? I don't know if this is a question for Erin.
Well, I will share what we can say from immigration, but we are not Medi-Cal experts. So what we can say is that deeming is separate from public charge. So deeming means that when the person goes to get a benefit, the eligibility person, when it's deciding if somebody's income qualifies them for that benefit, in some programs, they are required to consider the sponsor's income as part of that eligibility decision. So that is a separate concern than public charge. And my understanding is that different benefits do their deeming differently. So I don't know if there is a specific question about Medi-Cal or Medicaid and deeming that maybe a benefits eligibility person would like to address. From the public charge, we don't worry about that piece. We're only going to look at if somebody used a benefit that was cash aid or long-term institutionalization. And aside from that, it doesn't matter so long as, you know, the eligibility part is separate.
Carla, do you have anything to add from medical perspective on that, or Jamil?
For medical purposes, sponsor deeming does not apply. That only applies for CalFresh.
Great. All right, the next question, we received it in Spanish. I'll read it in English. So when a mom is filling out an application for food stamps, but doesn't have a social security card and her kids do, this would not impact the mom's immigration status?
Yeah, that's correct. We were saying that family member use doesn't impact someone else who might be subject to a public charge test in the future. So the mom's here, her children's use doesn't affect her.
And I just want to add that part of our jobs as us on this call is to tell mom, putting your name on this application as the mom is not a problem, right? Because she might not be applying for the benefit that kids are, and it's okay to be listed on an application as either the parent or as part of a household, and it will not impact her.
Thank you. Next question is, where can people get immigration consultations in San Francisco? I have here, free or low-cost immigration legal services are available to immigrants in San Francisco. Trusted community providers can be found at immigrants.sfgov.org. OCS page specifically about public charge, which I pasted on the chat earlier. And we as in HSA, we also have a public charge page that has commonly asked questions about public charge. So we'll share both links again on the chat. Rich, do you have anything to add?
Yes, I would just chime in that San Francisco has free or low-cost immigration services available. That's not the case in many parts of the state or the country. So we really encourage folks, if they have any questions, talk to an immigration expert. And we are very fortunate that here in San Francisco, there are many groups that speak many different languages that are qualified to provide this guidance. So definitely take a look at the two websites that we provided that have up-to-date information about public charge and a very useful tool to find a provider that speaks the language that you prefer and is located in the neighborhood nearest you.
Thank you, Rich. The next question is, are B2 visa holders eligible for Medi-Cal and or Healthy San Francisco? Carla, can you answer that?
Thank you, Beatrice. Yeah, they could be potentially eligible for Medi-Cal. So that's a visitor's visa. But remember, now regardless of your immigration status, depending on your age, you can receive full scope benefit.
Thank you. Next question is, do you have sponsor information in Chinese that we can share with clients who worry that if they use CalWorks, that this will affect their sponsor? Juan or Keres? We have Juan and Keres from our CalWorks division here.
Yes, hello everyone. With that information, yes, we can provide it to the client if the client is needed for the forms, instructions in Chinese. Yes, she can come to one of the Global Service Centers at 3120 Mission, or the client can come to 170 Otis. They can come even directly to us at the Employment Information Center, and we'll be glad to provide that information in their language as well.
And just to clarify, Juan, does that information say that receiving CalWorks does not affect their sponsor?
We will provide that information. In regards to the sponsor, as I was mentioning earlier about Ariel, of course, we're going to consider the sponsor information. It is on case by case. And the income of the sponsor will be also important to determine the client benefit as well. But it will affect the client themselves, but it will affect the benefit the client will qualify for, yes.
That sounds like it will affect the amount of aid that they receive
That is
because of income. Okay, but it's
yes,
not going to affect the sponsors themselves.
No, it's not affecting the sponsor. It was mentioned before, yes.
Okay, Ariel, I saw you unmuting yourself. Did you have something to add?
I mean, I was just going to say exactly what Juan was saying. It doesn't affect the sponsor from the immigration legal side. As Juan was saying, it would potentially affect the person who's applying for benefits, the benefits that they might receive. But a sponsor is not subject to a public charge test, so it doesn't matter. And then we also talked about that fear about sponsors having to pay back benefits received. And in California, there's no mechanism to do that. So won't affect the sponsor at all.
And for the person who raised that question, we have information that talks about this in our public charge page, HSA public charge page. There's specific questions about sponsors, and it is translated into Spanish, Chinese, Vietnamese, and Russian. So we'll share the link on the chat later on, and we'll also share it when we send the materials today. The next question is, if someone is on a U visa and is receiving CalWorks, will it be more difficult when this person is being sponsored by an employer or a family member for a green card, especially if the family is also low income?
Okay, we have this also, the U visa is not subject to a public charge test. That means this person doesn't need to worry. Also, my understanding is once they are on this U visa status, the next step on their path is they become themselves a legal permanent residence. They won't need any sponsor because they're on their way to becoming legal permanent residents. And also my understanding is they will become U.S. citizen, Ariel, and also Erin can confirm this. And it won't be needed any sponsor, as I say. If the family continue to be low income, what is important is there's some factors like the clients need to meet is if they meet the deprivation, income, property, and residency requirements. Yes. If the client is a U visa, low income, and meeting all the requirements, of course, the client will continue to receiving cash assistance benefits, food stamp, medical, and also the support services through the welfare program as well. But in this case, the client doesn't need to worry because client himself or herself is no, subject to a public test, charge for this. Yes, thank you.
Thank you, Juan. Erin?
Yeah, we agree. I just wanted to emphasize some of what Juan said, that U visa is one of those statuses that is public charge exempt. And then, as Juan has just said, even in a pathway to US citizenship, benefits used while as a U visa holder are exempt from public charge consideration. So those benefits would be safe to use because of that U visa application and status.
Thank you. Next question, what form or document does a U visa applicant need to apply for HSA benefits? And when are they eligible to apply for those benefits? So let's start with medical and CalFresh, Carla. What form or document does a U visa applicant need to apply for benefits, and when are they eligible to apply for those benefits?
So you can go ahead and apply for benefits as long as you have, you can just go and apply with the receipt, like when they go and file the petition for you for a U visa, they can go ahead and provide that as proof to the county that they are in the process. So in other words, they don't have to be approved U visa. They can, have a pending U visa and still be potentially eligible for benefits for both medical and CalFresh.
Do they need to submit any other documents to apply for benefits?
So once again, so as long as they have the receipt, and I believe it's the 792C is a document that shows that they have been fingerprinted. So any document, right, that they have that shows that they have applied for a UE visa, they can go ahead and provide it to us.
Okay, and
Did
aside
that
from
make
that,
sense? Sorry.
yeah, aside from that, they usually need to provide proof of ID, income, and other things as well, or is that not the case for U visa
Oh,
holders?
as far as immigration status, right, to determine if you have applied for a UE visa or not, the document that I stated earlier is sufficient, right? Now, to determine an eligibility, of course, yes, we need, your income, household composition, and other information.
Thank you, Carla.
Sure.
How about for CAP, Jeff? What documents does a U visa applicant have to apply, or has to submit to apply for benefits?
Yes, if a client want to apply for CAP, the cash assistance, right? By the way, we do have an online manual post on the HSA website. So it's a public information. So the community, they can access the information. For the U visa, they can provide evidence to show the applicant has applied for or have been approved for U visa, or the confirmation receipt or letter from USCIS verifying that request has been filed, or notice of actions form I-797, or the copy of a petition or EU non-immigration status form I-918, or EAD card, employment authorization document issued under category A19 or A20 for approved U visa petitioner, or any verification from USCIS or other authorities documents, right? So this information is on the website as well, on the HSA website.
Thank you, Jeff. So we do have different documents that we require for different programs. We just talked about medical, CalFresh, and CAP. For CalWorks, there's also additional documentations that we need, but what we can do is send a list of documents for each program along with the materials so that it's more clear for folks and so that we can keep going through the following questions. I did want to share that demonstrating that people have applied for benefits or have benefits with HSA can help waive immigration and naturalization fees. And so if you receive benefits or if you have applied for benefits, those fees can be waived. So it's important to mention that as you're thinking of, or as folks are thinking about the change in their status in the future. Ariel, did you have something to add?
I just wanted to add, that's a great point. You know, Erin mentioned when you apply for citizenship, that naturalization application, that's one of the main ones where you could try to either not have to pay the immigration application fee or pay a reduced fee if you show that you receive public benefits. Other immigration applications, though, don't always let you waive the fee. And a big one is if you're applying for a green card based on a family petition, you can't waive the fee in that instance. So just, it's not across the board, that's all.
Thank you. Next question is, which immigration statuses are not eligible for CalWorks?
Let me start, to which status are eligible. Those are eligible are U.S. citizens, lawful permanent residents, asylums that have been granted as well, those with U visa and T visa status, WAVA cases, U.S.-born children, as I mentioned it. The status that are not eligible are those status that are undocumented because they don't qualify for cash assistance. They don't qualify for CalFresh. However, they qualify for medical, as it was mentioned before. Yes. If they have any questions, they can give us a call. Also, the number that they can reach us is 415-557-5100. Also, they can check on our website and sfhsa.org. Or for more information, they can go to mybenefitcalwin.org, and then they'll find more information as well there. Thank you.
Thank you. The next question was submitted in Spanish. I'll read it in English. Are undocumented students who are applying for scholarships considered public charge? Erin or Ariel?
I was trying to let you get that one. Let me scroll back up. Was it undocumented? Sorry.
Yeah, are undocumented students who are applying for scholarships considered public charge?
No. So 2 reasons. Someone who is undocumented, unless they are applying for something, isn't looking at public charge unless they're applying to get a green card. And also, financial aid for school or education does not count in a public charge test. But separately, I will highlight that if someone has no immigration status, there are some federal financial aid possibilities that will not be available to that person. In California, we do have different eligibility than at the federal level for some financial aid packages.
Thank you, Erin. Next question is, Anna is undocumented and has a 10-year-old boy not born in the US and a 1-year-old boy born in the US. She's afraid of asking for CalWorks benefits. She has been told that this can affect a future legal status for her and her 10-year-old boy.
Ariel might want to add, but I can get us started, which is, this is one space where the new rule that we have since December makes it very clear that any family member who qualifies for a benefit can use that benefit and it will not harm other family members. So in this case, the youngest child who is a US citizen and qualifies could use the benefit that they qualify for, and it will not harm Anna and the other 10-year-old child.
Thank you. Next question. Numerous participants at our agency have told us that they have been told by HSA staff they're not eligible for benefits due to their status. in particular medical for parents, even emergency medical. Is there a contact for providers to share this concern when we are made aware of this? Carla?
Thank you. So like I mentioned earlier with the first question, when you are denied benefits, and that can be for medical or CalFresh, that letter will state the reason, correct, why you were denied your benefits. And there is also a number that it's from that you can go ahead and file a fair hearing or go ahead and contact the county so we can give you more information. Once again, I can go ahead and provide the 1-800 number. So if someone feels that they need to speak to an eligibility worker regarding the case, they can go ahead and do so. But it is important, so for all of us that are here today, right, please, review the notice of action. If you are dealing with, you're helping or assisting an individual, look at the reason why they were denied, and it will be very specific.
Thank you, Carla. Yes, and if when clients apply for benefits, if they feel like there was an error on our part or that the case needs to be reviewed more thoroughly, it is an option as well. You can request that a supervisor reviews the case to make sure that everything was done correctly. So that's something you can advise your clients. Clients in general are not denied for medical based on their status. Like we said, folks that are up to 25 years old, regardless of immigration status, they qualify for medical, and 50 and above, they qualify for medical as well, regardless of immigration status, for full scope medical. And from 26 to 49, they qualify for emergency medical based on income and other factors, but it's not based on their immigration status. So that's, yeah, just go ahead and ask our team to review the case if you feel like there was an error or if this person should be receiving the benefits. The next question is in Spanish. I'll read it in English. Can an undocumented single mom apply for CalWorks? Juan?
Yes, in the CalWorks program, we get to assess many single mothers. That is very important element. If the child is a US born or the child has other status, has a T visa or a U visa, as long as the child has legal status, single mothers, they can come to apply for CalWorks, receive cash assistance, food and medical. But I herself will not receive no benefit, but will receive it on behalf of the child.
Okay, thank you, Juan. Next question. Families are not being informed about the diaper benefit available now to medical for recipients. What is the internal protocol to inform recipients of the medical diaper bank?
I can add on that, or I can answer a little bit of that. So when I do orientations for CalWorks, I also inform the families that that they are eligible for diapers. And so I also posted, or the locations where they can pick up diapers. And I can also put that in our chat. And one of the locations, 170 Otis, 3125, 3120 Mission, but there are other locations.
Does anybody else have anything to add about how we inform clients that they have that access to the diaper bank?
We at the CalWorks program, specifically with our Employment Information Center, we have the flyers that we send, to the client, but those are the CalWorks clients that are receiving also diapers. I don't know if the CalFresh or medical, they have their own flyers as well, because in the past we were assisting only CalWorks, CalFresh, but medical program was later added, also to the eligible clients. It will be also good if medical program can send emails or flyers to the client informing them.
Thank you, Juan.
That they can participate receiving CalFresh. Diapers for them as well. Thank you.
Yeah, we just posted the link in there. We only have a few minutes left, so let's try to be as concise as possible so we can get to the rest of the questions as much as we can. So yes, we'll share the diaper bank website. We just posted in the chat and we'll post it afterwards as well. The next question also came in Spanish. If an American citizen asks for childcare for her daughter and wants to start the petition process for her undocumented mom, would this impact her, Erin or Ariel?
Sure, I can take it. So we're talking about the mother would be the sponsor for her mother, right? And so sponsors aren't subject to public charge like we talked about. So she should use whatever benefits she qualifies for and needs. And then also childcare isn't part of the public charge programs that could be considered. So again, should definitely use that program without worrying about public charge.
So no, it will not impact her.
That's right.
Great. Next question also came in Spanish. If you're in the process for a U visa and ask for financial assistance or scholarships for university, are you considered public charge?
So I'll go ahead and take that one. So again, for U visa, there is no public charge test. So if the person is applying for a U visa, they do not have to worry about public charge to get that benefit. And people with U visas are exempt from public charge, even if they move to a different application in their future. The other piece is what Ariel has explained, that financial aid for school does not count as part of the public charge test.
Thank you. Next question, can you explain the benefits or time limits, 8 months, available to recently granted asylee status? Where do they apply? I'm not sure who would be best for this question. Maybe the program folks or Erin?
Yeah, no, I think it's the program folks. If anyone wants to weigh in on your process for benefits for asylees.
Yes.
An asylee from the immigration side is eligible for benefits and service once that asylum status is granted.
Okay.
Yes.
Sorry.
With this also, the client has been granted asylum status. I believe they can go directly to the CAPI program if they're singles, or if they have children as well, they've been granted asylum, they can come to CalWORks program and we'll assist them. And if they're single, they can get 8 months, I believe, with us at the CalWORks program. And then they have to be in the status of a rich refugee, not being granted. I don't know, Ariel or Erin can also add to this. But I believe in the refugee status, this means that they have like they receive only 8 months through the CalWORks program, and then after they exhaust it, and also they can be added another 4 months after 12 months. After they exhaust their benefits or the time limit with us of 12 months, 8 to 12 months, clients are being transferred to the CAPI program to continue with the cash assistance and First America. And they are welcome to come to apply.
Thank you.
Thanks.
The next question came in Spanish. I don't know if this question applies to this topic, but I wanted to ask, if my daughter, who is an American citizen and is 21 years old, she petitions for me, do I need to go back to my country for 10 years if I came to the US with a visa? And unfortunately, we cannot answer these questions here since it's not related to public charge. There are many factors that go into deciding whether someone must stay out for 10 years. So it's best for you to get a consultation. We have resources on these slides and the PowerPoint presentation of different agencies, as well as the agencies that OSIA has shared with us. So you can check out those links. I'm sorry, we cannot help with that. The next question is, will you be able to send a copy of the questions asked in a Word document after the presentation? Yes, we will compile this. Just be patient with us as we gather all the information. Next question, can you please share the address for the mission facility? I'll ask somebody from our team to please type our address on Mission Street. I'm guessing it's the 170 Otis. Or maybe let's just post the different addresses that we have available. Next question is, will applying for CalFresh affect patients who are undocumented? I get many clients who ask if applying for public benefits will expose their immigration status and lead to possible deportation.
Yeah, so Aaron talked about this sort of at the beginning. Public charge is not an immigration enforcement tool. And then also, especially in California, we have a lot of confidentiality protection so that someone's information isn't going to go from the benefits granting agency to ICE or other immigration enforcement agency. And then the sort of the only exception that we talk about is where someone is in a status that can be verified with a really serious criminal history, but otherwise they shouldn't have to worry about that.
All right. We still have a few questions and we have only 2 minutes left, but we'll follow up with the ones we can get to. The next one is, what immigration statuses are not eligible for CalFresh? Carla?
Sure. So if you're here on student, work, or a tourist visa, also DACA and TPS are not eligible for CalFresh benefits, as well as undocumented individuals.
Thank you. Are people with TPS eligible for any public benefits?
Stated before, for CalFresh, they are not, but they can go ahead and apply for Medical. So that will fall under the category of being undocumented, correct? And depending on the age, they could get restricted or full scope.
Great. The last question, it came in Spanish. How early in the pregnancy can a pregnant mom start receiving diapers?
Anytime when the client is also already provided that information that is pregnant with a specific due date, provided medical verification file, even the child hasn't born yet, they can come to the office. Specifically, 170 Otis will be able to provide diapers for the client.
So anytime they can verify that they're pregnant, is that correct?
Yes, because most of the
great.
times it's always showing in the pregnancy window with us in either medical, and us can check it out. Yes.
Thank you, Juan. All right, so this concludes our webinar today. We will be sharing, like I said, the PowerPoint slides and the recording afterwards. We'll also include a survey, and we would appreciate it if you could fill it out to help us improve in future webinars. Thank you again to ILRC and OSIA for your partnership to make this possible, and to our HSA staff and OSIA staff for all your help and contributions. And thank you, of course, to all of you for dedicating the time to learn about public charge with us today. Thank you so much. Have a great rest of your day.